Hello, everyone. This is Caleb from King's Advisors. And thanks to the courts, we have a really big story today. Now, yesterday, Friday the 18th, a federal judge upheld a finding from the U.S. Copyright Office that pieces of art created by AI are not open to protection. Now, this is a story out of the Hollywood Reporter. So I'm going to pull this up on screen and I'm going to kind of talk about this. So let me explain why this is such a big deal. So here in the United States, copyright protection can only be given to a work created by a person. So you've got these writers today who are on like their 110th day of striking, terrified that studios are going to start using AI to either finish scripts or write scripts altogether. But it would appear that the federal courts have just taken this completely off the table. So if Disney uses an AI to write a script, they won't have a copyright on that script, which means they can't protect the script from other people using it. I mean, they could physically put it in a vault and only take it out when they're filming. But once that movie comes out, that script can be redone. Someone else can film that movie again using the script. Judge Howell, the federal judge that decided this case, wrote in her decision, human involvement in and ultimate creative control over the work at issue was key to the conclusion that the new type of work fell within the bounds of copyright. Now, let's travel back in time for a bit. We're going to go back to the 1880s. And we're going to look at a case involving Oscar Wilde. Now, Mr. Wilde sat for a series of photographs by a guy named Cerrone. Cerrone was a very accomplished photographer at the time. So Oscar Wilde sat for like 20-something photographs. Now, everyone that knows anything about old photography knows that that took a long time. So he sits for all of these photos, and they're done in different styles with different lighting and different backgrounds. Some clothing was different in some of them, all these differing things. And that's one of the reasons why it took such a long time. And so number 18, the 18th picture, comes out really good. And so a company called Burrough Giles Lithographic Company takes the photographs and makes a bunch of prints without Cerrone's permission. So Cerrone sues. So this is number 18. This is the photograph that Cerrone took and that the lithographic company stole. So Cerrone sued the company saying, I own the copyright on this and they're abusing my copyright and making money off of it. The lithographic company argued that Congress didn't have the right to extend copyright protection to photographs and that you could only copyright writings. Now, the trial court in New York was kind of in doubt of whether or not Congress had the right to extend copyrights to photographs. But they didn't overturn it, and they agree with Cerrone, and so Cerrone won. The lithographic company appealed, and the U.S. Circuit Court found the same. And then the company appealed to the Supreme Court. And the Supreme Court found, and this is the big thing here, the Supreme Court found that it wasn't the fact that Cerrone had pressed the button or pulled the trigger or however you did it back then. It was the fact that Cerrone had placed Oscar Wilde in this position, that he had changed the lighting, that he used the background in this way, that the chair was to that angle, that the stuff on the chair was there. It was the human aspect and the evidence of that aspect visible in the picture. That's why Cerrone was granted the copyright. It wasn't pushing the button. It was the human element on camera. And that's what's missing in this case here from the Hollywood Reporter. There's no human element involved in this picture. Further down, we see Judge Howell talk about another case. Here, in another case, the Federal Appeals Court said that a photo captured by a monkey can't be granted a copyright since animals don't qualify for protection. And the big thing here, Howell cited in her ruling The plaintiff can point to no case in which a court has recognized copyright in a work originating with a non-human. That's the big thing here. There has been nothing in the past to create precedent for this. And this was decided by summary judgment. Now, for those of you who may not know or may have only heard of summary judgment in our wonderful lawyer TV shows we have today, let me explain what summary judgment is really quickly. So, when a lawsuit starts, you have the pleadings, you have a summons and a complaint, and sometimes some other things, but it starts with a complaint. And then the other party is summoned to answer the complaint. And they answer with an answer. And you move through discovery, which is when you get most of your evidence. And then any party can move for summary judgment. And what that means is there's no genuine dispute as to any material fact. And a material fact is any fact that could allow the fact finder, that's the judge or the jury, to decide against the person asking for summary judgment. And when the judge looks at summary judgment, they have to look at all the facts in a light most appealing to the non-moving party, which means the side that isn't asking for summary judgment. So if John sues Dave, and Dave, after discovery, moves for summary judgment, then the judge will look at the facts as if they support John. And if looking at the facts in that way, there's no question for the judge as to whether or not John is telling the truth, then he or she will find for summary judgment for Dave. So the reason I explain this is to try and explain just how big of a losing hand Mr. Thaler, the plaintiff in this case, had. The reason I'm talking about this is not just because I love copyright and trademark. It's because I think this could be a big reason that gets these Hollywood strikes over with. You know, both SAG and the WGA keep talking about money and AI. And I find it unlikely that the studios give the kind of money that both unions are looking for. But seeing as how the studios have basically lost the battle on AI now, I think it's very possible that we'll see them cave a little bit more on the money side, you know, so that we can get back to work and start having TV shows and movies to argue over. So I think it's very likely that these strikes will soon be ending. Of course, we've also got the fact that both sides have been meeting. I think today they're on like their 4th day of meetings, which I believe is the longest time they've met together since the strike started, I think. So that could be another thing. But I do think that this decision by Judge Howell plays a really big role in all of this. And I think it really answers the question of, you know, how will AI be used in art in the future? And that answer is sparingly. As always, I'm Caleb. Thanks for watching. And don't forget to hit that like button, subscribe, and follow us on Twitter at King'sAdvisors_.